Hi, it's Caitlin Jenkins, the family law vlogger here. One of the questions that clients often ask me is about the various different ways in which you can get divorced, so the different processes that you can use. The subject of other vlogs are things like mediation and the court process, but today I was just going to tell you a bit about the collaborative law process. The collaborative law process is a process whereby people use solicitors to help them, or barristers actually, but solicitors or barristers to help them resolve the issues arising out of their relationship breakdown. Now, instead of using the solicitors to negotiate in a series of letters or in a court or on the telephone, in a collaborative process, the clients try and resolve their issues in a series of meetings called four-way meetings. And they're called four-way meetings because at those meetings there are the two clients and the two solicitors. So everything is dealt with in a series of meetings rather than on the telephone or in other forms of correspondence. Now, one of the advantages of this is that, unlike mediation or most forms of mediation, this means that the clients actually have their solicitors in the room with them as the discussions are taking place, so they have immediate access to input and support. So how does collaborative process work? Well, first of all, you and your spouse or partner need to decide that the collaborative process is right for you, and then you each need to find lawyers who are trained in the collaborative process because it's an extra layer of training. The collaborative lawyers will then talk to you or to talk to your spouse to check that they think it's appropriate for a collaborative process. And then you'll have your first meeting. At that first meeting, all four parties, so the lawyers as well as the clients, sign what's called a participation agreement. And it's that agreement that sets the tone for and sort of regulates how the collaborative process will go ahead. Some key things in the participation agreement are that, as I say, all four of you sign it, and that the parties are agreeing not to go to court whilst the collaborative process is ongoing. So it doesn't mean you could never go to court, but if the collaborative process is ongoing and you're still negotiating, then you can't go to court in the background or in tandem. If the collaborative process breaks down, then of course the court process is still available, but you can't then use those solicitors who've been helping you collaboratively to take the case to court. And the idea of that is that both the parties and the solicitors are really invested in trying to get the right outcome using the collaborative process, because the solicitors can't be involved further if the collaborative process breaks down. There are some other differences with the collaborative process in that it's a different way of negotiating, really. Instead of a couple or one party to a couple wanting to make sure that they get the absolute best deal for themselves, the collaborative process involves both parties being prepared to think about the other and really think about what collaboratively might suit their family. So not necessarily just the best deal for them as an individual, but what might actually work for them overall as a family. So when is a collaborative process suitable? Well, it requires quite a high level of communication. So the couple still need to be able to communicate even though the relationship's broken down. It requires quite a high level of trust and certainly a high level of transparency, because if you're going to be able to think about the other person's point of view, you need to be prepared to be entirely open and straightforward about your position and to be willing to understand what the other person is saying. It also requires specialist lawyers, so those who are trained collaboratively. And importantly, it requires two people who are prepared to not just put their own interests first, but perhaps think about the interests of the other party, or perhaps the children or somebody else who has got an interest in all of this being sorted out in as amicable a way as possible. Collaborative process is not suitable for those where there's been domestic violence or domestic abuse, but your collaborative lawyer would be able to screen the case for that to understand a bit more about your situation and whether collaborative law is even an option. So as a collaborative practitioner, I would say that collaborative law is a really helpful option for those for whom it's suitable. As always with the family law vlog, if you have any actual questions that relate to your specific circumstances, so if you want to know whether the collaborative process might suit you, then you should take specialist advice, and my details and those of the Mills & Reeve team are at the end of this vlog.